president to these are new.
Welcome. My name is Carl Miller. I'm a programming director here at the Federalist Society, and it's a pleasure to welcome our two speakers today. Mr. Tyler Lindley is a fellow at the J. Reuben Clark Law School at Brigham Young University and is of counsel at the appellate litigation boutique Lee Nielsen. He graduated from BYU with his BS in economics and from the University of Chicago, the law school, with high honors with his JD. He clerked for Judge William Pryor on the U.S. Court of Appeals for the 11th Circuit and will be clerking for Judge Gregory Katsas on the D.C. Circuit Court of Appeals. Mr. Lindley's writing has been or will be published in the Alabama Law Review, the Wake Forest Law Review, the BYU Law Review, the University of Chicago Law Review Online, and Newsweek. We're also joined by Professor Tom Ginsberg, who focuses on comparative and international law from an interdisciplinary perspective. He holds BA, JD, and PhD degrees from the University of California at Berkeley. Professor Ginsberg is the author of several books, including his latest, Democracies and International Law. In 2018, he co-authored, along with Aziz Huq, How to Save a Constitutional Democracy, which was awarded the Best Book Award by the International Society on Constitutional Law. Professor Ginsberg currently co-directs the Comparative Constitutions Project, and before teaching law, he was a legal advisor at the Iran-U.S. Claims Tribunal at The Hague. He continues to advise numerous international development agencies and foreign governments on legal and constitutional reform. Professor Ginsberg is a member of the American Academy of Arts and Sciences and currently co-hosts the Entitled podcast on human rights. And with that, please give a warm Illinois welcome to our speakers today.
Thank you. It's not often that people come to Chicago to get to the good weather, but we left 2 feet of snow in Utah last weekend, so it's a very warm welcome in more ways than one. It's also strange to be back on campus and not in your seats. Lunch talks, including by FedSoc, but also by all the organizations, were a great part of my law school experience. Didn't come from a legal background or have legal people in my family, and it's really a great way to hear about things, and hopefully I contribute to that for you. It's also a stranger for me to have Professor Ginsberg providing commentary. I appreciate him. He was my professor for comparative legal institutions and canonical ideas in American legal thought. And so from the time that they told me that he'd be providing commentary, I've been having dreams about him standing up and giving me a grade from 155 to 186 on my presentation. And given my grade in some of his classes, those dreams were nightmares. They were not enjoyable. My talk has 2 parts. They asked me first to talk a little bit about my path as a young scholar. It's the first time I've called myself that in public. It feels wrong, but going into academia and the things maybe I wish I knew in law school. And then to talk about what has come to be known as the writ of erasure fallacy and its relationship with recent administrative law challenges, especially concentrating on removal restrictions for agency heads. They relate to each other in my life chronology, but not necessarily in substance, so hopefully I can keep you going through as I move through. When I entered law school, like all 1Ls who know nothing about legal careers, I knew exactly what I wanted to do. And I wanted to go in academia. But luckily, even though my decisional certainty greatly dwarfed my relevant knowledge, even a blind mouse finds cheese once in a while, and I still wanted to go into academia. I think the best place to start is with the piece of advice that I got during law school. I was fortunate to have only a few things that I wish I would have known or mostly just understood better, I was told. Because my mentors, including the faculty here, Professor Ginsberg among them, were so helpful for me. And so that will be one of the things I talk about. But some disclaimers first. I'm obviously not in academia. I'm doing a fellowship right now. That's about as far away as you can get and still call it academia. But I'm not really in academia. I haven't made it. I might not make it. There's still a long way to go. So my advice might not be as helpful as someone who's in a different position in their life. But I was recently in law school and got a lot of really good advice from what I've seen. So here's the advice that helped me most. First is to make sure that this is what you want to do. Although there are a variety of faculty teaching positions at any law school, there are 3 large buckets of job responsibilities: teaching, scholarship, and citizenship. And you see the teaching and the preparation that goes into it, and and after. Maybe you will see the scholarship if you pay attention to Law Prof Twitter or any other ways to keep up with that. But there's also the citizenship aspect, which includes mentoring students during law school, but also after, writing letters of recommendation, law school administrative activities and committees, attending conferences internally and externally. And you don't have to love every part of the job, but you need to understand that if the only reason you want to go to academia is one of those three, that you'll be doing a lot of other stuff as well. And understanding and making sure that you will enjoy the job as a whole is important, not just some parts. Second, don't do things just to go into academia. I know I'm speaking to some people who already have PhDs, but when I came into law school, I had read some old advice online because I didn't think anything had changed. And so I heard that the standard advice was you go to a good school, get good grades, maybe write a paper or be working on a paper and go to academia. That's what you do. But I found out that that's not really been the path to academia in these days. In 2022, 66% of entry-level hires had a higher degree in addition to a JD, and 40% of all hires they were doctorate degrees. And no, JDs don't count. We're not doctors. 79% had some form of fellowship, and only 10% had either just a clerkship or none of those three, with most of those 10% having at least one clerkship. So I had a young family, didn't want to move for a fellowship. I didn't think I was going to fall for a lot of reasons in that 10%. So when I found it out, I instantly thought, wow, I either need to get a PhD or give up on it. But I had no real desire to get a PhD, no offense to the people who want to or have already. It sounds and sounded miserable to me. But fortunately I had a mentor that told me not to do the PhD if the only reason was to get another line on the resume to go into academia. And so if something adds value to the scholarship you want to do or you enjoy it, by all means do it. But don't just focus on getting stuff just to build up on the resume. 3, of course, get good grades. I don't know on the entry-level hiring. I've seen some of it at BYU Law School, but also it'll just help you get the fellowships and into the programs that will help you hone your presentation skills. As you can see, this is something that I did not take advantage of as much when I was in law school, or you will see. But this is both formal and informally, and I think I didn't necessarily take advantage of all the formal opportunities that the law school offers, but the law school also offers a lot of informal opportunities. When you're telling people about your papers, there's a lot of curiosity, especially at this law school, and that was really, really helpful to me. You often will just get short periods of time with coworkers, with scholars in other fields, to communicate that your ideas have value, that they're right, that they're interesting, that people will want to read them, that you're an interesting person. And in the law school community, this is a great example. This is a great opportunity to do this now. So take advantage of it while you can. Also, 5th is to keep up to date in your field. And you might not know what your field is, and so obviously if it's much broader, then you can't do very much depth. But try to keep up to date on recent decisions, recent scholarship, popular writings. It was helpful to me because it gave me some ideas. It gave me concrete arguments maybe on the other side or that were adjacent but not necessarily exactly what I was arguing. They also make you aware of what's going on, so you don't sound like you're writing something and you think it's really important and everyone else knows that people have written on this recently. 6th, I think that this one is the most, if you take away one thing, this is what I would probably hope you take away, is to keep a list of ideas in law school and clerking and in practice of potential scholarship. I remember Professor Bode telling me this during the spring of my 1L year, and my only complaint is that he didn't tell me earlier, because if I had any thoughts worth anything my first year, I completely forgot them. And not all of your ideas will be good. Most of mine are not. My list is full of ideas that I've crossed out that are under the heading questionable viability. And even some pieces that I'm still planning on writing about, but just the opposite of what I initially wrote on my list. I did get a few ideas from this list to turn into articles, but I think that's only half of the value. Scholarship is not necessarily a natural thing to do, and I'm still learning how to do it. But it gets your mind training about ideas, how to think about these types of questions, what kind of questions are interesting, how to fill gaps in scholarship. 7 is to write in law school. I think you have more time now I'm only 2 years out, but looking back, you have more time now than you will at any other point in your career pre-becoming a professor. You have and you also have more resources. You have a library that's open to you that's just down the hall, or you're studying in. You have professors assigned to read your papers. They can't get away from it. You have professors who are willing to supervise independent studies, classmates who are eager to talk to ideas through you, who aren't busy trying to bill hours and are annoyed that you keep texting them about things. And sometimes, at least when I was in law school, I was hesitant because I didn't want to write something because I knew I didn't know about it. I knew that in 3 years I'd write a much better paper. But sometimes you don't have to know a lot to dive in and write a useful paper. Sometimes the value is just doing the research. But also, you can take a really bad paper and it's easier to revise over time as you learn. And you can keep it for a while. You don't need to necessarily make it public immediately. In fact, my talk today is focused on a part of an article that I started in Canonical Ideas for in American Legal Thought that Professor Ginsburg taught at the time. I turned it into an essay in my 3L year because the Supreme Court took a relevant case, as you'll see. But some of the ideas in that essay I actually think now are wrong, and I've changed. But after clerking and at the start of my fellowship, working it and workshopping it with more people, it was still something that was a core that was useful to me rather than starting from scratch. And so now a couple of things that I wish I would have known or better understood in law school, and then I'll transition to the substantive part of my remarks. The first is my writings in law school that were useful to me after law school were the longer articles. I did an independent study with the idea of making it into a longer article. I worked in the canonical seminar, but my shorter writings assignments in law school and seminars were not helpful. And I know a lot of people who put more thought into what they were writing in seminars, and their shorter writing assignments turned into essays or parts of longer articles. And I look back at my essays now, and to the extent that they're coherent, I don't have any desire to do anything with them. And so I think that could have been a more effective use of my time had I slowed down and taken some more thought on those. And then the second, I was lucky to have some professors really take an interest in my career and help me, but I didn't fully grasp how important it was to take advantage of that while you were here, of getting to know professors and learning from them, but also even beyond school, they'll continue to want to help you. And those connections are really important, especially as you're moving back into academia, because they're often the people, even years out, they're the people that have spent the most extended length of time with you and can speak the most to how you would contribute to a faculty or would not. So to the substantive part of my remarks, I was in the fall of my 2L year, and it would have been 2019, and I was in Professor Ginsburg's class trying to think of an idea to write a full-length article on that I had never done before, that was 3 times longer than anything I had ever written before. But one of the ideas that was occupying my mind was what was then a fairly new article and a concept that was named the writ of erasure fallacy. It was an article by Jonathan Mitchell, and the idea had been circulated before. He didn't invent this. John Harrison had written about it in 2015. Brian Lee had written about it. It existed before, but of course, when someone gives a catchy nickname to something, it often sticks, as our own Professor Bode knows about the shadow docket. So simply put, the judges commit the writ of erasure fallacy when they purport to strike down or nullify laws that are unconstitutional, but then treat those laws as if they are vetoed, repealed, or erased. So the linguistic error is an important part of the fallacy, that they say they strike down or nullify a law, but that's really not the primary part of the fallacy. It's how you treat it after that decision. So judges could technically say that they're striking down a law or nullifying a law, but then not treat that law as vetoed, repealed, or erased. and not commit the writ of erasure fallacy, and vice versa. Those who don't say that can still commit the fallacy about how they treat a law. And it's a fallacy because the judicial power, at least as originally understood and granted to federal courts by Article 3, doesn't enable judges to repeal statutes or remove them from the United States Code. Such a system was considered and rejected in 1787, rather, sorry. Instead, the judicial power includes the power of judicial review. And judicial review, as understood in the 18th century, said judges must enforce a statute if it was validly promulgated and constitutional, but they have an obligation not to if it's unconstitutional. And so it's a choice of law problem where they have to treat the statute as if it doesn't exist because the Constitution is the higher law. And this remedial limit was recognized by early federal courts, but the rhetoric around it didn't always reflect this limitation. And over time, courts increasingly used careless language, even if they weren't treating laws incorrectly. And then that language over time led future judges and scholars to come to believe that the judiciary had some veto power like the executive, or a repeal power like the legislature. So state courts aren't necessarily bound by it. Georgia law expressly allows state courts to repeal or to void laws, but this is mainly a question of federal law. But I will say that the state-federal distinction maybe gives further evidence that federal courts don't have this power, because we allow state courts to conduct federal judicial review, but it would be odd if we gave state courts the ability to veto or repeal or erase a law that Congress had enacted. The idea that the federal judiciary should wield the writ of erasure predates the Constitution itself. At the Constitutional Convention, the Virginia Plan included a council of revision that would include judges from the national judiciary, but would have other participants as well. The Council of Revision would review each law, including state laws that were enacted. As you can tell, not very many laws were enacted back then, if you can imagine a council having to review every law from every state. And they could veto any law that they deemed unconstitutional or unwise or unjust, was the proposal. This dissent, as it was called, was subject to an override if the law was passed again. Similar to a presidential veto, it wasn't the last word, but there was a check. Influential founders such as James Wilson, George Mason, and James Madison supported the council, but they were repeatedly defeated. The convention rejected Madison's separate proposal to give the Supreme Court itself an independent and separate veto power. Edmund Randolph proposed various proposals to give the judiciary more veto-like power over state laws and federal laws that would have preempted state law. But they were defeated over and over again. And those defeated founders continued to assert that the newly created federal judiciary that didn't have the powers they wanted it to have, did have the power to render statutes void. And so that perception that happened that was prevalent among the defeated founders then came back into the majority over time as this language was divorced from the context. So for example, one reading of Marbury versus Madison advances this idea. Chief Justice John Marshall said that an act of the legislature that is repugnant to the Constitution is void. In fact, Mitchell, in his article, asserts that the use of the word void suggests a permanent nullification by the judiciary. And that is one construction of the word, and that's, as I mentioned, Georgia state courts that can void them use the term void. But it's also possible that the use of the word void meant what the court said nearly a century later in 1880 in Kilburn versus Thompson, where they specified that the judiciary must treat the act as void in performing its judicial duties. In any event, this separation between the language and how you treat the law is important to this administrative law concept that is being affected today. So the opposite of the writ of erasure fallacy is to accept what I call a remedial limit. Basically, it says that federal courts can remedy specific harms to parties, and in doing so can ignore unconstitutional laws, but they cannot veto, repeal, or erase that offending statute. So even after they have adjudicated a dispute between two parties and said that a law is unconstitutional, it still exists. Whether that law will be effective in future cases is decided by other laws, such as stare decisis, the law of precedent, or other things, because the statute can be amended, repealed, it can be attempted to be enforced in different situations. But ignoring that remedial limit often has the effect of allowing courts to opine on statutes even when it would not affect the rights of the parties. I think that the most obvious example of this, if you consider the most recent challenge, the Obamacare challenge that was decided by the Supreme Court in 2021. There, the individual plaintiffs, the state plaintiffs had a slightly different argument, but the individual plaintiffs, and the Fifth Circuit accepted this argument, they argued that they felt compelled to follow the law just because it was the law, even though there was now zero penalty for failing to maintain insurance. So they said the mandate is unconstitutional. I have a harm from that mandate because I follow the law and I purchase insurance that I don't want. And if you, the court, declare that the law is unconstitutional, then I won't buy the insurance anymore and it'll remedy the harm. The District Court and the Fifth Circuit agreed and ultimately determined that the law was unconstitutional because it no longer raised a tax in 2012. The justification for upholding it was the taxing power. But those decisions by the District Court and the Fifth Circuit didn't change the law, and neither would have a favorable decision in the Supreme Court. If the individuals felt compelled to follow the law before, for whatever reason, they would have similarly felt compelled to do so after. The only difference would be a judicial decision saying that in their opinion, the law was unconstitutional. But generally, in fact, all the time, we don't allow people who just want a judicial decision because it makes them feel better to get one. Ultimately, the court on appeal ruled that the defendants did not cause the injury. It was the statute itself, not the Secretary of Health. But they still dismissed for lack of standing and didn't reach the redressability concern that nothing the court could do would remedy the injury. So that's a standing implication, and I think that those are interesting as well, but they're a little bit more straightforward. That happens in the Establishment Clause as well. The city of San Francisco passes a law saying we don't like these certain Christian beliefs and wish that they would not be promoted. It doesn't change anyone's rights. Just a court saying that this violates the Establishment Clause doesn't do anything to that proclamation. The City Council of San Francisco still believes that Christian beliefs are wrong. Nothing happened because the court intervened. But those implications are fairly straightforward. But sometimes this causes a remedy problem. There is standing, but then on the back end, the remedy that the court is providing doesn't match the harm. So imagine a court decides a constitutional question before determining whether the challenger is entitled to relief if the provision is deemed unconstitutional. In that case, only if the determination that a law is unconstitutional is itself a remedy is the constitutional adjudication related at all to the remedy that might come or might not come to the party. So if courts could strike down or excise these statutes, then arguably in this case it would be doing something. If it ultimately determines that the party is not entitled to a more concrete remedy, it's still doing something. It's striking down the statute, it's excising, it's forever changing it. But if they can't, then that adjudication is at best potentially necessary to the remedy and to resolving the dispute. So even though they're still standing, it still allows courts to reach the constitutionality of laws when it might not affect any one person before the court. So sometimes this happens in separate opinions. The Supreme Court says this law is unconstitutional and then remands back to determine whether there's a remedy. But I think in more egregious circumstances, the court determines in the same decision that there's a constitutional problem, that a law is unconstitutional, and that the plaintiff or the challenger is not entitled to a remedy. In that case, it seems fairly obvious that if now assuming the premise, if the opinion has no effect on the statute, then the opinion is functionally an advisory opinion because they don't do anything other than say, we think that it's unconstitutional, but you guys have to go home, you guys don't get a remedy. And because there's no binding effect outside that case, It's unclear whether those parties are bound by that decision in the future, whether future parties would be bound by the law of precedent. It offers some conflicts in the law once we assume that that didn't do anything and then the parties get no remedy. But as I mentioned, sometimes on appeal, the constitutional decision does do something, so that it's not that it's untethered from an ultimate judgment. Maybe the court, instead of affirming, vacates and remands, and even if the ultimate decision is that the challenger isn't entitled to relief, the appellate court didn't know that, but it seems to violate the law of constitutional avoidance, or the doctrine of constitutional avoidance, where it's only potentially unnecessary to resolve the controversy. And so the more prudential route would be to decide whether or not the challenger would be entitled to a remedy. Okay, so now I'm getting more concrete. I know I've talked at a very high level of generality. What does this have to do with administrative law? Well, in the last decade plus, the Supreme Court has decided that various statutory provisions that restrict the president's ability to remove agency heads violate the separation of powers. I think the most famous has been the CFPB, where the court determined that they had enough, the CFPB had enough executive power that the president had to be able to remove her at will. So, but in none of these three cases, I'll talk about Free Enterprise Fund versus AAB, excuse me, Sealer Law versus CFPB, and then Collins v. Yellen. So this is about a board underneath the SEC, the CFPB, and then the Fair Housing Finance Agency. Did the Supreme Court decide that the challenger was entitled to any relief in the case? They decided the constitutional question and didn't decide the remedy. And each of them raised slightly different concerns, and I'll go through them. But in all of them, the court addressed that constitutional question before determining whether there would be a remedy in the end and whether it would affect the rights of the parties. So like the standing problem in the Obamacare case, even though that's a little more obvious, it risks injecting the court into abstract questions of constitutionality. And I think in today's day and age, as we see where the court's legitimacy is increasingly being questioned, there's a lot of shifts, however large or small you think there certainly are some shifts that are going on. And so I think that this is detrimental ultimately to the institutional reputation of the court, but also something that appears to be incompatible with the original power of the judiciary, which, to the extent we care about that, should be troubling. So as we'll see in the court's recent decision in Collins, if the problem becomes more acute if the standard for getting a remedy is higher. And the court in Collins set it fairly high. So what happens is it allows courts to vindicate what they see as these fundamental separation of powers principles, and they really do care about it. But then at the same time, they avoid destroying the administrative state, crippling the economy if the worst projections are to be believed. They avoid all of that by ultimately not giving a remedy, purporting to change the statute, and then allowing everything to move as it did before, all while just tweaking some of the presidential control. Consider first Free Enterprise Fund. The challengers there sought broad injunctive relief against the board's continued operation on the theory that there was a dual layer of removal restriction, couldn't remove the SEC head and then couldn't remove the board members. And so on the theory that that was unconstitutional. The court said it was unconstitutional, but then said, quote, it was severable from the remainder of the statute, and so, end quote, and so the board could continue to exercise all the power it had, quote, because the tenure restrictions were excised, end quote. The district court on remand followed the marching orders, issued a declaratory judgment saying these are unconstitutional, they're severable, they're now excised from the statute, and we can move on. And then that was it. And then it denied the plaintiffs any of the relief they were actually requesting from the board's decisions. But there's a problem, I hope you can all see. The removal restrictions were not excised. In fact, the court did nothing to them. If you go and look in the US code, they're still there. In Westlaw, they'll have the little red flag, but they still exist. And so if a future court overturns that decision, which very well may happen, Congress won't have to act, and there will be removal restrictions on the head of the PCOAB. On remand, the district court denied the challenger's request again, and then just declared that they were unconstitutional. But that declaratory judgment, like the Supreme Court's statement, did nothing to the statute. And so the court purported to have issued a declaratory judgment, but declaratory judgments are authorized in the Declaratory Judgment Act to declare the rights of the parties. But again, if they did nothing to the statute, then it did not necessarily declare the rights of the parties. So if the problem becomes even more stark when we look at the Supreme Court's decision, it decided that the removal restriction did not affect the rights of the rights of the challengers. It said the decision itself was not affected by the removal restriction, and it said that there was no likelihood that the challengers would be subject to a future decision that would be affected by the removal restriction. And that's how they justified not giving any concrete remedy. But if that's true, if that constitutional decision, whether it was unconstitutional or not, had no effect on the challenger's decision from the board, then it's unclear why the court felt justified in reaching the constitutional question. And again, the court gets to enact its desired change to the administrative state without undoing any past administrative action or preventing the agency from acting going forward. It gets the best of both worlds. Consider next seal law, which is in 2020. There, the court concluded that it was unconstitutional to insulate the head of the Consumer Financial Protection Bureau from presidential removal. But then it said that the removal restriction was severable because the provisions bearing on the CFPB's structure and duties remain fully operative if you take out the offending tenure restriction. But again, the Supreme Court decision did not take out the offending tenure restriction. Before and after the decision, the statute purported to restrict the president's authority to remove the CFPB director. Before and after the decision, that restriction was not the governing law because it was displaced by the Constitution, assuming, of course, the ultimate conclusion that the court reached was correct on the merits. The court's decision just recognized what the law was not. It was not to allow this restriction on removal. Unlike in Free Enterprise Fund, the court in seal of law did not, in its own decision, expressly foreclose a concrete remedy for the challenger. It remands to the Ninth Circuit, but its order of operations effectively sealed seal of law's fate. So let's look at what happened on remand. The court remanded for a question of whether an interim acting director who was removable at will during the time that the decision was made and being enforced, whether that ratified the decision, even if before there was an purportedly insulated director, and after there was a purportedly insulated director. The Ninth Circuit takes the case and requests briefing. In the briefs, the then current CFPB director, who again in the litigation agreed, she was part of the Trump administration, she agreed that the removal restriction was unconstitutional, but was arguing about the remedy. She says, now that I know, because the Supreme Court has told me that the removal restriction is unconstitutional, I ratify all of the current decisions, including this enforcement action. The Ninth Circuit says, that's good. The CFPB director now knows she's removable and she still chose to enforce this decision. You get no remedy. Your remedy has already been given to you because now you have a perfectly removable director enforcing this decision. But it's unclear how before the decision versus after the decision, CFPB director knew or didn't know. If the Ninth Circuit's conclusion is just about a determination on the likelihood that the court will enforce or refuse to enforce the removal restriction, then it's unclear why a court couldn't have done that before. Why a court couldn't have said, well, we looked at the Supreme Court's cases and how they're coming. We also look at the membership of the court. They're not going to enforce this. Therefore, the director is removable, in fact, and there's no harm. But in any event, the more concerning, in my mind, conclusion by the Ninth Circuit was that the ratification remedied any constitutional injury that seal of law may have suffered, and resolved any concern the seal of law might have had about inadequate presidential oversight and control. So the Supreme Court, by choosing to resolve the constitutional question first before the remedy, made sure, combined with the Ninth Circuit's reasoning, that seal of law, the challenger would get no relief. So again, able to decide these constitutional questions, enact their desired change without affecting anything, including the case before them in the real world. The third and final example is Collins v. Yellen. There, the court concluded that the statutory removal restriction protecting the FHFA violated the separation of powers. Again, the similar conclusion. This time, even Justice Kagan joins on stare decisis grounds after seal of law. The challengers, they were shareholders in Fannie Mae and Freddie Mac, sought retrospective relief for harm arising from a contract signed between the FHFA and the Treasury. So this presented a more complex problem. It wasn't just future harm going forward, but they wanted to reclaim some dividend payments that Fannie Mae and Freddie Mac had paid to the Treasury, essentially damages. The court reasoned that an unconstitutional removal provision, finally reaching the question of what you need to do to get a remedy, did not automatically render all of these actions void. They concluded that a challenger must establish that the removal restriction you must have evidence that it affected the decision you are specifically challenging. So it gives some guidance on what evidence would be sufficient and remands the case to the Fifth Circuit. But if ultimately the Fifth Circuit decides, and the Fifth Circuit remanded to the district court, so ultimately if the district court, the Fifth Circuit, lower courts decide that the removal restriction never affected the challenger's rights, why would the court weigh in on whether the removal restriction was unconstitutional? Of course, maybe the answer is their hands were forced by the lower court decision. But on what basis would any court, lower court or Supreme Court, be able to issue a declaratory judgment about the statute's constitutionality if it doesn't end up mattering in the dispute about the administrative action? So Justice Gorsuch wrote an interesting concurrence in Collins where he agrees on the constitutional question but disagrees about the remedy. He argues that when an officer is unconstitutionally appointed, when the officer is unconstitutionally appointed, this court's decisions are that say that those actions, so subsequent actions, are void. He says that they, in a sense, the FHFA head was unconstitutionally appointed because he was given executive power in circumstances that he shouldn't have received it, and so therefore it was void because both the executive power grant was a problem and the removal restriction. Either one of them taken out would have solved the constitutional problem. It's only significant executive power grants that must not be accompanied by a removal restriction. So Professor Bode, in his recent article, Severability First Principles, argues that Justice Gorsuch may have committed the first half of the writ of erasure fallacy because the removal restriction was never actually law and so did not actually affect the validity of the grant of executive power. So because it was never law, therefore the grant was effective, and it's not the case that all of the subsequent actions are void. And to be sure, the removal restriction did stay the same before. Whatever legal effect it had before, it had the same legal effect after. But Justice Gorsuch didn't necessarily endorse an approach that requires a different legal effect before and after. And I think that's why Professor Bode says may. He doesn't take a position. But let's see what Justice Gorsuch's position, which I think avoids this problem that we're talking about, even if his view on the remedy might not be correct. So we have an unconstitutionally appointed officer, and I'll discuss that, and then an unconstitutionally insulated officer. An officer, if he doesn't get his executive power correctly, he's unconstitutionally appointed, then no court decision saying he was unconstitutionally appointed will give him that executive power. So therefore, the court has to deny all of his exercises of executive power that are challenged before court until he's properly appointed, either by Congress, by an agency head, by the president. But if an officer is unconstitutionally insulated, then there's two problems. It's not just the appointment problem, it's one of two. And so perhaps what Justice Gorsuch is saying is, until Congress decides which of the two they want to keep in, there is no effective grant of executive power, because they granted executive power only together with this removal restriction. And so that grant was ineffective until they decide to grant it without the unconstitutional removal restriction. Now again, I think, at least as far as the the court's jurisprudence is currently trending. I think the correct answer to that is just a matter of history and the law of remedies. Maybe the writ of quo warranto, which was a writ in the 18th and 17th century that removed both public and private officials. Maybe that's the answer. I'm not sure, but at least that's a coherent way to think through it. That Congress has to decide which one they want. Do they want the executive power without the removal restriction? And until then, the agency can't act. But of course, that is extremely damaging to the administrative state, especially if the court is going to look to a lot of older statutes and find that there's a separation of powers problem. That is a lot of past actions to unwind, subject obviously to statutes of limitation. But that's also, there are very important agencies that won't be able to act until Congress acts. And I don't know about you, but I don't have a lot of faith in Congress being able to act quickly, especially depending on the agency. So we have this problem where as long as we have a high bar for a remedy, then we shouldn't be answering the constitutional question very often. But if we have a low bar to the remedy, then there's going to be significant practical consequences. But returning to Collins, unlike in the Ninth Circuit and seal of law, the Fifth Circuit couldn't have addressed the potential ratification because of the retrospective relief. If you remember, they're requesting damages. So the Fifth Circuit remands to the district court to determine causation. But in seal of law and Collins, the court was arguably justified in reaching the constitutional question because the lower courts hadn't resolved the non-constitutional issues. They also reached for the constitutional question. So it's the lower courts then that could have and should have decided on non-constitutional grounds and ultimately bear the greater fault. But returning to Free Enterprise Fund, which did the same thing, it's excusable or forgivable at least for these lower courts to think that that's what they had to do. In fact, the two swing justices in the Fifth Circuit in Collins, they said, we think that the removal restriction is unconstitutional, but we look at Free Enterprise Fund and the proper remedy is just a declaratory judgment and no concrete remedy going forward. But now, maybe with the court's better instruction on the remedy, that won't happen as much, except for the fact that in Collins, the court did not expressly repudiate what happened in Free Enterprise Fund. So it'll be interesting to see how lower courts but how they choose between these two paths. But as long as the lower courts and the Supreme Court are weighing in on hotly disputed constitutional questions, even if unnecessary to adjudge the legal rights of the litigants before them, then we're going to have this situation where the court can vindicate these constitutional separation of power principles while avoiding the risk of collapsing an entire agency or crippling the agency's ability to act, negatively affecting the economy. In Collins, Justice Gorsuch perhaps cynically explained it as such. Today, the court sounds the call to arms and declares a constitutional violation, only to head for the hills as soon as it's faced with a request for meaningful relief. And again, there are two ways to solve that. One is to not call to arms and declare a constitutional violation, and the other is to give meaningful relief. And I don't know what the answer to that question is, but the current pairing doesn't seem to work. So now I've complained for about 20 minutes about what the courts are doing. What's the right way for courts to fix this problem going forward? Especially lower courts who can't tell the Supreme Court to officially overrule the remedy determination in Free Enterprise Fund. They're limited. What can they do? And I want to start by saying I don't think that the justices are doing this on purpose, and perhaps I've, by explaining the effects of their decision, implied that this is what they're trying to do. I think that this is a tricky area of law, and there hasn't been a lot of attention to it. And I've tried to say the years on purpose. And 2010 was Free Enterprise Fund, but it's not until 2015 and 2018 that these articles about the remedial limit are really coming to light. So I don't think that there's a purposeful dissonance to change the administrative state without being blamed for crippling it. But I do think that there is this intuition, maybe it's motivated reasoning, maybe it's just when they're going to be willing to consider overturning precedent, where they don't want to return to a New Deal era in which Congress has to act to resolve every constitutional problem, but they also don't want this administrative state that's independent and at least arguably non-responsive to democratic means of control. So what can lower courts do? One pushback that I have received, but also I think that a lot of people are saying, fights the substantive conclusion. They say removal restrictions are constitutional. There's been a lot of scholarship by Professor Sugarman at Boston now, Professor Jane Mayers at New York University. There are others that appear convinced that the president does not have the constitutional authority to remove officers, even with significant executive power. But that doesn't seem very likely to me, and again, if you're a lower court, you have to follow the Supreme Court precedent. Even Justice Kagan joined in the majority on the constitutional question in Collins. So it's unlikely that that's going to change going forward. Some people say, well, maybe the courts need to increase deference. Some of these questions are close, whether there's significant executive power, whether multi-member boards change the analysis. But again, that might narrow the scope of the problem, but I don't think it will resolve it completely. Because remember, the Ninth Circuit in SELA law actually rejected the constitutional argument, but didn't reach the non-constitutional grounds. And so they still were addressing constitutional questions when there were other avenues to resolve the case. So I think if the court isn't willing to bring down the administrative state, which I'm not saying that they should or shouldn't, but or if they want to at very least avoid even crippling agencies or unwinding many of their past actions, then they just shouldn't be hearing these cases. Courts are not roving legislatures. They don't get to fix every unconstitutional injustice or every injustice period. They don't have a veto power as much as maybe they would like to. The problem is more acute for these lower court judges. What are they to do? And maybe the problem will resolve itself a little bit. Maybe they'll choose to address the remedy question first. But maybe the court will continue to get these questions, and maybe they need to explicitly tell lower courts to address all the non-constitutional grounds first. But in the end, I think we see a court that has made a lot of constitutional decisions and has covered a lot of ground in these constitutional adjudications. And I don't argue that when the case presents itself, that they need to do their best job of what they think that the law requires. But here is a situation in which arguably the law not only doesn't require them to reach a constitutional question, but requires them not to. And in those cases, they should. Thank you.
Thanks, Tyler. Your rate is 184.
Oh, thank you.
Yeah, sorry about that. I didn't realize that. It was taking my nightmares, But anyway, it's great to have Tyler back, and it's always wonderful to have our graduates back, but especially when so recently, is delving really into, as you can see, very deep questions of legal scholarship. Just so you all know, if no one's told you, that nothing the faculty likes better than our students becoming professors. It's just like the natural thing. If your father's an engineer, he wants you to be an engineer. If you go to law school professors love you to do it. And we do a lot to help. And so if any of you are interested, please be sure to reach out. And in due course, you could decide this in 5 years, or you could decide this now. Yeah, I'd like to just respond a little bit to some of Tyler's provocations here. One first point, of course, is that we're really unique, actually, among constitutional systems because of the lack of a clear basis of what the courts can do. Voiding statutes is bread and butter for constitutional courts around the world, and arguably, that's a pretty functional way to do it. Now, we lack that, of course, because, the power comes, power comes from Marbury. And I was going to ask you, under your framework, isn't Marbury itself unconstitutional? That's a case where they look at the statute, they say statute's unconstitutional, but we have no remedy. There's no redressability. Maybe they shouldn't have taken Marbury to begin with, and then we wouldn't even have any of this discussion. But just that very fundamental question about the source of judicial review. Now, we do know, of course, that the framers did understand and expect there would be judicial review of statutes. There was plenty going on at the state level, and so we've kind of muddled through. And muddling through is generally, it's what we do here in the United States, and it invites then some attention to pragmatics, right? Not simply treating it as a holy text handed down, perfect, but trying to have workable government, which is of course where many of these cases involving the Ministry of State come, sound in that pragmatic set of questions. To some degree, and I guess one question at a fairly high level of abstraction is, there's lots of rule of law values at stake here. One of them is following courts not going beyond their initial grant of power. But another, of course, is certainty and predictability. And if all a court can do, and we all agree that this is all a court can do, is order future courts to follow precedent in a like case that comes up next. They can't void the statute. Jonathan's right. They don't void the statute technically. But if that's all they can do, given then that we have also coordinate construction, that Congress and the executive are also constitutional players on the same plane with the Supreme Court, able to interpret the Constitution on their own, well, doesn't that create a lot of uncertainty, actually, as a pragmatic matter? Because now there is, contra Cooper Vieira, and there is no final decider, but you're also saying that the court should also refrain, really, from speaking out too much. And that might actually create a lot more uncertainty, certainly about the constitutionality of these various agencies. And that's why I was a little less concerned about these appointment cases, perhaps, than you, because at the end of the day, maybe it is helpful for, for the court to spell out, peekaboo, that the head of that agency board, can be fired at any time by their principal. It's only a ripe case when someone comes along and fires the next one. But now we know that, and that's going to affect all future relations between that head and their principal who appoints them. Double for causes removal is not okay. That means that in some sense already, the first minute that case is decided, cabinet members have a lot more power over the agencies that they oversee, and that's a good thing, and that probably improves accountability, has all these effects, in other words, outside of law that we might think are really useful. Now, I was going to ask you a couple technical questions. I don't want to take too long, so maybe I won't say everything I was going to say. But yeah, it strikes me that you're making redressability really, really central. And of course, there again, not only other rule of law values, but other elements of a standing test, that might be met. I was going to ask you about, and this maybe you don't have any answer, but abstract pre-enforcement review in administrative law. So I assume you'd be against that, like toilet goods and that line of cases, where again, maybe there's not yet ripe injury, and yet, it's really helpful prospectively to know whether this regulation, which looks like it's ultra vires, is going to be allowed to stand. Again, that's the kind of thing where, as a practical matter, parties really do want to know, even if it sort of violates some formal limit on the case and controversy requirement. I think that's probably a good thing in my opinion, given the power of the administrative state. Let's see. I wonder if I want to say any more, actually. Yeah, I mean, it's a messy time. We're in this weird place where the courts, stepping back is sort of part that it seems very unseemly for the court to step into these things and then not grant specific relief. And yet, probably down the road, if you think about the balance of all these powers kind of working together, and I agree with you, Congress is not going to step in a lot of the time. I think we do nevertheless want some prospective guidance to ultimately the executive branch, which is the main player here in administrative law. With absent, if the court's stepping out and Congress never acts, well, just as a very gross, crude matter, that means there's a lot more executive discretion, which generally strikes me as maybe the biggest problem that we face in a constitutional order. Again, this would have all been clearer if the framers had been more explicit in their grant of powers to courts. The courts have to work out what they're going to do, but staying out of everything is also not an acceptable. There you go. So I'll just leave that, and then hopefully you can respond if you want, but there may also be many questions from the floor.
Okay, I think we have time for a couple questions. James?
So thank you for coming out to speak to us. I thought this was a very interesting talk. The whole idea of declaratory judgments and other non-injunctive technical remedies seems to sit kind of poorly with the idea of the writ of erasure fallacy to me. And specifically in the context of Collins v. Yellen, which you were talking about, the idea of the combination clause that Professor Bode is talking about in the severabilities paper. How do you think that specifically catches out there with the idea of these non-adjunctive equitable remedies? Because if action on the law is a non-starter, if we're kind of taking that as a premise, then the declaration that the court is presumably issuing doesn't actually issue any guidance to Congress or to the parties. And it seemed like what you were saying is there's no guidance issued to the parties, but if in the context of accommodations problem, there's no guidance issued to Congress either, does that create kind of an extra layer of difficulty on top of what you're already saying?
Yeah, so if I understand you correctly, thank you, this is a really, I think, a very insightful question. If I understand correctly what you're saying, I think that comes down to the question of how a court writes the opinion rather than what the judgment says. And so I can see a world where you have declaratory judgment where in order to make it fit in the constitutional structure and under the writ of erasure fallacy, it needs to be sufficiently tied to the rights to where it looks a lot like an injunction, but it isn't. But that it's the other part, it's these non-party but interested parties that are really what would really like some guidance Congress. If I understand it correctly, that's kind of the framing of your question?
Yeah.
Okay, and then I think that in the end comes down to the opinion, and that's a separate concern, but I think it's completely valid. So I can see a declaratory judgment that says, yes, we've looked at all these statutes, there's something wrong, you can't enforce it. And that maybe gives guidance to the parties in that case. One party's a repeat player, so it doesn't give him much guidance going forward, other than if you have an array of these where you can kind of map out a problem, but it gives almost zero guidance to Congress, right? And I think that, again, comes down more to the question of how do you write an opinion? And I know Professor Bode in another article that he's written called The Judgment Power says that opinions are still helpful because it gives parties an ability to plan your affairs in the future, and that still matters, but that's just not the same concern we're talking about with the remedy. And so I might, if the court starts doing that, then I might come back with another paper saying, hey, you still have to write an opinion. You have a dispute resolution role, but there's other things, there's other values. Similar to what Professor Ginsburg was saying, is there's other values we have, and maybe we can address those other values in other ways. And in this case, it would be writing a clearer opinion, which I'm a big fan of clear opinions as well.
Mr. Rippon.
Can you answer Professor Ginsburg's question about Marbury? Because I was going to ask that too.
Yeah, of course. So I think there is a read of Marbury where this creates a similar problem. My view of Marbury is framed by, I think Professor Michael Stokes-Paulson has an article about this, but there are others as well. It's framed that the reason why there was no remedy was because the statute was unconstitutional. If the statute was constitutional, then there would have been a remedy. So it was necessary to decide the constitutionality question because if it was constitutional, there was a remedy. If it's unconstitutional, then there's no remedy. But there are other people who have taken other positions as well, and I agree that if they're right, then Marbury has a similar problem, and it wouldn't be beyond Chief Justice John Marshall to try to change society instead of write laws or write opinions.
I think we have time for one more question.
Yes.
I'm curious about the historical argument, because it seems that a lot of the case relies on the Council of Revision's rejection for establishing the Constitution did not intend to allow courts to void
Yes.
laws, and that the Council of Revision was discussed under the context of the executive branch of authority. I'm from Massachusetts, where we still have the Governor's Council,
Yeah.
and that's very much an executive branch thing. And a lot of the discussion, I've read the Mitchell article, and that's
Yeah.
transparent, and a lot of the discussions taking place in this that Mitchell cites are discussions
About the
about the extent of executive authority, where people are taking for granted that courts, when discussing constitutional laws, can override things, but they're discussing like involving the court in an
executive function.
in an advisory fashion, and then giving the court additional powers to that. So like, how does the constitutional contention, rejecting the idea that there should be an advisorial council of judges to the executive who could overrule laws on non-constitutional grounds? How does that rejection mean that the constitutional convention didn't want, especially when
Yes, of course.
and we all know they can also do it on constitutional grounds already.
Yeah. So I think I totally get it. I think it's a really, really good question because even in my article I said it has members of the judiciary on it, but it is an executive function. I think that there are some the evidence is less strong on this about how seriously it was considered and for what reasons it was rejected. But there are other arguments that relied on a judicial version of the Council of Revision, like Edmund Randolph's plan. But I do agree that the evidence is not quite as strong there. I think, in my opinion, it's combined with three things. You have the revision rejection, which is a lot of the bases are we want Congress and the president's veto. And so it's by implication, I agree, but there's some basis there, and I don't think it gets you there. Then I think you have the middle ground, which is the text itself, which if you look at other judicial review that was happening at the time, just like Professor Ginsburg said, this is not a surprise. The often repeated line is Marbury invented judicial review. It was around a lot. It might have been the most famous example of it, where he really, maybe an unpopular decision really bears into a president, but it definitely was around, and that's how it operated there too. They viewed it as kind of a choice of law problem, and then so you go to the text there. But then I also think, to the extent that you believe in some form of like liquidation or tradition-informed interpretation, or even if you're not an originalist at all and you're looking at kind of like a common law, early in the cases, I think that Mitchell gives too much ground on Marbury, saying that Marbury thought he was voiding the statute, because even if you look at the statute itself, it was just one part of the larger Judiciary Act, and he enforced that same section, not even just the Judiciary Act itself, which he did 100 times, but he enforced that same section in other cases as well, which I think would be inconsistent, at least facially, with the idea that he took out the section because it was unconstitutional. Now, maybe he said, I only need to take out this one word, but again, you'd think that the opinion would have a lot more discussion on that, or future decision would have a lot more discussion on that. So I don't think there's any one smoking gun evidence, but I think when you combine all of those, the argument's pretty strong. But again, my argument kind of takes that as true, and to the extent you disagree with that, then we're talking about a lot of different things here. And I think that's just real quick to finalize my answer to Professor Ginsburg's other questions about, is readjustability too strong here? What about the administrative state? We have a lot larger administrative state than we did then. I think my question, maybe this is naive, and it very well could be, maybe would be Professor Ginsburg's response is, if that's the case, then we should structure our judiciary a lot differently than we do now. We give them a lot of independence, we give them life tenure. Impeachment is basically a non-starter for 99% of the cases, if not more. If we're going to allow them to play a larger role in our government, which may be good, then we maybe should enact some other reforms so that they're more democratically accountable, because I'm not sure if a democratically unaccountable administrative state is any worse than a democratically unaccountable Supreme Court doing the same thing.
Well, thank you very much, Mr. Lindley.
What'd you say?
I appreciate your comment.
No, that's great, thank you. Awesome.